Our class, good morning. So our lecture for today is Special Crime Investigation 2, part 2 of our lecture on this subject. So lesson objectives is define what is evidence, define what are the three I's of criminal investigation, define what is information, discuss two kinds of information, define what is interrogation, discuss what is admission and confession, define what is instrumentation, and discuss what are the type of medical evidence. So let's get started. So what is evidence? So unsa ang ebidensya? Evidence is the means. So it is the means sanctioned by the rules of court. So unsa nag-sanction niya? Rules of court of ascertaining in a judicial proceeding the truth respecting a matter of fact. So ascertaining in a judicial proceeding the truth respecting a matter of fact under Section 1, Rule 128, Rules of Court. So, if the means employed to prove a fact is medical in nature, then it becomes a medical evidence. So, remember it, class, and take note of that. When it does become medical evidence, so if the means employed to prove a fact is medical in nature. So the three I's of criminal investigations. So as we can see, these are called the tools of the investigators. So namely, information, interrogation, and instrumentation. Their application varies in proportion depending on their necessity to establish the guilt of the accused in criminal trial. So what is information? So information, it is the knowledge which the investigators or investigator gathered and acquired from other persons. So muna siya ang knowledge daw na gina-acquire nila sa mga tao by the investigator. So information is important in investigation because it answers the question, who did it? So once it is acquired, such information will enable the investigator to try to solve the problem in order to find the proper solution. So there are two kinds of information. So information acquired from regular sources such as conspicuous and public spirited citizens, company records, files, or other agencies. Number two, information which the investigator gathers from cultivated sources. So try to remember kung saan yung mga information acquired. There are two: acquired from regular source or acquired from cultivated sources. So when you say cultivated sources, it acquires a technique to acquire such knowledge either by intelligence or skillful questioning, like cab drivers, license owners, and employees in general, former criminals of acquaintances. So interrogation. So what is interrogation? Take note, it is the process of questioning witnesses and suspects to obtain further information. So the effectiveness of interrogation depends on the craft, logic, and psychological insight of the interrogator in interpreting the information relevant to the case. So the difference of interview and interrogation is that the interview may be used to mean the simple questioning. So take note, it is a simple questioning of a person who is cooperating with the investigator. So the key is simple questioning, and that the person who is being questioned is cooperating with the investigator. So when you say interrogation, maybe hesitant, the person in question may be hesitant or doesn't give the exact information, so the investigator may lead to vigorous, skillful questioning so that he may acquire information by the reluctant and to divulge this information. Try to remember it, class. So, what will the investigator do to penetrate the reluctancy of the person? It is vigorous and skillful questioning. This is also called interrogation. So, admission. When you say admission, it is a self-incriminatory statement. So, the key is self-incriminatory statement by the subject falling short of acknowledgement of guilt. It is acknowledgement of a factor in circumstance from which guilt may be inferred. So, it is implicated but does not incriminate. So, pwede ka mo admit na ikaw ang nagbuhat, pero it doesn't mean that you are being guilty by the statement you are given, because kailangan pa man na siya i-process through court proceedings, through investigation. Next, confessions. When you say confession, it is a direct acknowledgement. So when you say admission, like that, it is a self-incriminatory statement. Ibig sabihin, nalukong na ka, ibig sabihin ka ng nalukong na ka ba? So, para ma-save ka, di mo na lang i-admit. So, a confession is either it is a direct acknowledgement of the truth of the guilty as charged of someone, essential part of the commission of the criminal act itself. So, direct acknowledgement. So, the keyword is direct acknowledgement. Instrumentation. What is instrumentation, class? It is defined as the application of instruments and methods of physical sciences or science in detection of crime. It is the application of physics, chemistry, biology in crime detection. So remember that all of the sciences is produced to detect crime. It is the sum total of the application of all sciences in crime detection. So other known as criminalistics. So there are different branches of criminalistics. There are photography, forensic ballistics, so and so on and so forth, because it includes all the technical methods by which the fugitives may be traced and examined. So what are the types of medical evidence? There are autoptic evidence, testimonial evidence, experimental evidence, and documentary evidence. So when you say autoptic evidence, so these are evidence made known or addressed to the senses of the court. So makita sa korte because it addressed the senses of the court. So it is not limited to that which is known through the sense of vision, but it is extended to what the sense of hearing, taste, smell, and touch is perceived. So lahat ng senses. So ano yung mga senses na yun? Hearing, taste, smell, and touch, and vision. So whenever an object had such a relationship to the fact in issue as to afford reasonable ground of belief respecting the latter, such object may be exhibited to review. So like we say, it is addressed by the vision of the court. So that example, these are objects which are exhibited and viewed by the court, or it is existence, situation, condition, or character proved by the witness, as the court in its discretion may determine under Section 1, Rule 130 of the Rules of Court. So, testimonial evidence. So, when you say testimonial evidence, these are evidence which a physician may be commanded to appear before a court to give his testimony. While in the witness stand, he is obliged to answer questions propounded by the counsel and proceeding officer of the court. His testimony must be given orally and under oath or affirmation. So hearsay evidence. So what is hearsay evidence? These are those not proceeding from the personal knowledge of the witness. So it is not perceived by the personal knowledge of the witness, but from mere repetition of what he has heard. So what you say, what is this? He acquired it by hearing it to others, repeated communication by others from one person to another, so until na abot sa iya. So muna iya na acquired na information. So it is a second-hand evidence which rests mainly on the veracity and competence of its sources. So when you say veracity, iyang kabugaton. Unsa ba yun tinuod ni iyang pagstol ay iyang gi-testimony na against sa accused kung tinuod or dili. Section 36 and Rule 130, Rules of Court. So the difference between expert and ordinary witness. So we will add a discussion about this class. So when you say ordinary witness and expert witness, or for example, a physician who testifies in court on matters received from his patient in the course of physician-patient relationship, there is an exception, privilege of communication between physician and patient under Section 24, Rule 130. So when you say expert witness, physician on account of his training experience can give his opinion. So try to remember that his testimony is by opinion due from he acquired through his training and experience to set a medical facts, to made a medical fact, so he can deduce or infer something or determine the cause of death or render opinion again pertinent to the issue and medical nature. When you say ordinary witness, it may be the physician giving statement based on what he received from his patient through the court. So when you say physician expert witness, when a physician based on his training and experience, he can give opinion to determine the cause of death or render pertinent issue. So experimental evidence, these are evidence when a medical witness may be allowed by the court to confirm his allegation or as corroborative proof, so additional proof to an opinion he previously stated in full view of the court. So there is a medical witness, for example, this is the witness is having a gunshot wound. So to confirm his allegation, he must provide proof that he is being shot by this person. So he must provide itong pusil or handgun or anything na malink ang object sa suspect to prove his allegation. By asa man niya i-prove niya? In full view sa court. Dapat makita sa court. So document evidence is written evidence presented to the court by the expert witness about the subject matter in dispute. So when you say document evidence, so kinsa may mag-present ani? Remember, expert witness, because iya maning depensahan ang document. So these are subject matter in dispute. So these are written in dispute. These are also called question documents. So example of medical documentary evidence are medical certification or report on. So examples: birth certificate, death certificate, medical examination report, physical examination report. So second is medical expert opinion, and last is this deposition. So when you say medical expert opinion, So this refers to the testimony of a physician on account of his training and expertise can give his own opinion on a set of medical facts. So try to remember it, guys. So it refers to a testimony that a physician, by account of his training and expertise, can give his own opinion on a set of medical facts. So when you say deposition, it is a testimony of a witness taken upon oral questioning or written interrogatories or interrogation, not in open court. So wala sa korte gihimo ang deposition, but in pursuance of a commission to take testimony issued by a court or under general law or court rule on the subject and reduced to writing. So pwede niya i-reduce to writing siya, and duly authenticated and intended to be used in preparation and upon the trial of a civil action or criminal prosecution. So affidavit, pwede makabuhat og affidavit. So end of our lesson. So we will continue our lesson next week, and before we will having our exam, we will add more lesson to our topic before our exam. Thank you and God bless.